The HOA's common property list included my guest house, even though the building sat behind my home on my parcel. A board email said residents could use it that weekend, so I captured the listing and objected before anyone arrived. The manager stood by the designation and cited an old site plan as the association's authority. Then the county tax map showed the guest house completely inside my lot lines. That created an uncomfortable question. Was the HOA correcting a mistake or protecting something that depended on the mistake remaining in place? Would a tax map settle this for you, or would you demand more proof? Add your view in the comments. The next step revealed why the label mattered beyond one weekend. The first sign that this was more than a bad label appeared in the comments under the announcement. One resident asked where to pick up the access code. Another said her sister was arriving Friday and wanted to reserve the guest house for 2 nights. Someone else thanked the board for finally opening our community cottage. I did not blame any of them. They were responding to information the HOA had published as official. But every comment made the situation more urgent. If residents arrived believing they had permission to enter, the dispute would no longer exist only on a website. It would be happening at my back door. I saved the entire page as a PDF, took screenshots showing the date and time, and forwarded the board's email to a separate account. Then I walked behind my house and photographed the guest house from every side. The door still had my lock. The electric meter fed from my property, and the water line ran from the main house. Nothing outside suggested that the building belonged to the association, except for an old walkway approaching from the common green. Back inside, I wrote to the property manager, every board member, and Evan Rusk, the developer representative who still controlled a majority of the board seats. I kept the message simple. The guest house was on Lot 18. I had never given the HOA permission to advertise it, enter it, rent it, or distribute access codes. Until the ownership records were reviewed, I demanded that the listing be suspended and all visits canceled. I attached the portal screenshots and asked for a written response before Friday morning. The manager replied less than an hour later. She said the building had always been identified in association records as a shared amenity and that the board was reviewing my objection. She did not remove the listing. She did not cancel the weekend access notice, and she did not explain who planned to issue the code. That left me with one immediate problem. I needed to stop anyone from entering without turning confused residents into enemies. I checked the windows, tested the lock, and posted a plain notice on the door stating that the building was private property and that access had not been authorized. Then I returned to the portal. The booking page was still active. By that evening, it showed one reservation request awaiting confirmation. The reservation forced me to look at the HOA's explanation more carefully. The guest house had not appeared out of nowhere. Years before I bought Lot 18, the developer had used the building as a sales cottage. Prospective buyers met there, reviewed floor plans, and walked through the model homes. An old path still connected the building to the green space on the east side of my property, which made it look like part of the common area, if you did not know where the recorded boundary ran. The next morning, the manager sent me the document she said the association relied on. It was a faded site plan showing the cottage beside an area marked for future community use. A dotted walkway ran from the green to the building, and a note identified it as a future guest cottage. At first glance, it supported her position, but the page was labeled preliminary. There was no recording stamp, no final plat reference, and no indication that the boundaries shown there had ever become the legal parcel lines. It looked like a planning document from the early development stage, not proof that the HOA owned the building. I replied that I was willing to review every recorded document the association had, but the portal listing needed to come down while that review happened. The manager said the board would consider the request. Later that afternoon, Evan contacted me for the first time. He did not accuse me of taking community property. He said the guest house had always been presented as an amenity and that changing its status without a full review could create confusion for residents. That sounded reasonable until I noticed what he avoided. He did not identify a deed transferring the building to the HOA. He did not point to an easement giving residents access. He did not explain why a preliminary plan should override the documents from my closing. Most importantly, he did not suspend the booking page. The developer still had several homes left to sell, and the guest house appeared in community materials as one of the features residents could use. I did not yet know whether that mattered, But Evan's wording made one thing clear. He was worried about more than one weekend reservation. By Friday morning, the HOA had given me its authority story. Now I needed to find out whether that story survived the county records. The county parcel website was not difficult to use. I entered my address, selected Lot 18, and opened the map layer that showed parcel boundaries and building footprints. The guest house appeared inside my lot, not near the line, not partly across it. The entire footprint sat within the boundary drawn around Lot 18. The HOA's green space began on the other side of the eastern line, and the old walkway stopped where the common parcel ended. Nothing on the county map showed a separate access strip leading to the building. I downloaded the parcel map, the property card, and the page listing the structures associated with my address. Then I called the county office before treating any of it as final proof. The employee I reached was careful. She explained that the online map reflected county parcel data, but it was not a boundary survey and did not decide legal title. Parcel maps could contain errors. Recorded deeds, plats, easements, and field evidence still mattered. That was not an instant victory, but it exposed a serious contradiction. The HOA was telling residents that the guest house belonged to the community. The county system used to organize the parcel showed the building as part of Lot 18. Even if the tax map could not settle the dispute by itself, it gave the association a clear reason to stop access until the recorded documents were checked. I sent Evan and the manager a second written notice. I attached the tax map, highlighted the guest house footprint, and marked the boundary between my lot and the HOA green. I repeated my request that they suspend the listing, cancel the reservation request, and instruct every contractor and resident not to enter the property. Evan answered that county mapping was not conclusive and could be outdated. He said the association would continue relying on its own site plan until council completed a review. He was right about one thing: the tax map was not the final word. But his response raised a different question. If the county map, my closing documents, and the physical location of the building all pointed toward Lot 18, why was the HOA so determined to keep the booking page active while the review was still pending? The request had not been canceled. The guest house was still listed as common property. I spent the rest of Friday pulling together every document I had received when I bought the property. My deed described Lot 18 by reference to the recorded subdivision plat. The title policy ensured my ownership of the lot, subject to listed exceptions. Buried in the closing package was an older survey showing the guest house behind the main residence, along with utility records connecting the building to my property. None of those documents, by itself, answered every question. Together, however, they formed a stronger packet than the county map alone. I organized the evidence in the order I thought mattered most: the HOA listing and access email, the county parcel map, my deed and title policy, the old purchase survey, and my written objections with the manager's replies. I sent the packet to Evan, the property manager, and the association's counsel. I again asked for 3 temporary steps: suspend the booking page, cancel the request, and confirm that no resident or contractor would be given access while the records were reviewed. HOA counsel replied late that afternoon. His response was cautious, which made it harder to dismiss. He wrote that the county tax map did not determine title. He also said my deed had to be read together with the final recorded plat, which I had not yet obtained. The association's declaration, he added, authorized the HOA to manage community facilities, but it did not identify whether this particular building qualified as one. In other words, he did not say the HOA owned the guest house. He said the documents needed further review. That should have been enough reason to stop the booking temporarily. Instead, the listing remained active. By then, residents had started discussing the dispute on the community message board. A few assumed I was trying to take back an amenity that had always belonged to everyone. One person asked why a homeowner should be allowed to block access to something included in the neighborhood's advertising. I understood their frustration. They had been told the guest house was theirs to use. But arguing with them online would solve nothing. I saved the comments, kept every communication in writing, and focused on the missing document the HOA's own lawyer had identified, the final recorded plat. Until I saw it, I had evidence of a contradiction. What I did not yet have was the record that could explain which map controlled. The following Monday, I hired a licensed surveyor. He immediately separated 3 questions that everyone else had blurred together: who held title, where the boundary actually ran, and whether the HOA had any recorded right to enter or use the building. He asked for my deed, the old purchase survey, the subdivision plat reference, and every easement listed in the title policy. He explained that the county map could reveal a conflict, but a proper boundary opinion had to come from the recorded description, field monuments, and measurements on the ground. While he scheduled the fieldwork, I ordered the final plat from the county recorder. I also asked the HOA to provide the exact preliminary plan it had been using, including any approval or recording information attached to it. Then I reviewed the exceptions in my title policy. There were utility easements, drainage provisions, and standard subdivision restrictions. Nothing I found gave the HOA a right to enter the guest house, manage it, or send residents across Lot 18. That was encouraging, but I knew an incomplete search could create false confidence. I needed the recorded plat and the surveyor's work before drawing a firm conclusion. The physical threat returned before either one arrived. On Tuesday afternoon, a contractor appeared near the guest house carrying equipment for a keypad inspection. He had a work order from the management company and had been told the building was part of the HOA's amenity system. I did not block the common walkway or threaten him. I showed him my written objection, the county map, and the email confirming that ownership was under review. I told him I had not authorized work on the building and asked him to contact the manager before touching the lock. He stepped away, made a call, and left without changing anything. Later, the management company gave me a copy of the work order. It had been marked Ownership Authorization Unresolved. An attachment also listed a keypad kit and a small common property sign that had been reserved but not installed. That notation mattered. Until then, the HOA could describe the problem as a disagreement over maps. The work order showed that its claim had already moved beyond paperwork and toward a change in physical access. For the moment, the door was still mine to secure, but the survey had not been completed, the final plat had not arrived, and the HOA still had not removed the guest house from its system. The final plat arrived 2 days later. I opened it beside the preliminary site plan and compared the two line by line. The earlier plan explained where the association's claim had come from. It showed the old sales cottage beside land intended for future community use. A dotted walkway ran from the green space to the building, and the page labeled it a future guest cottage. The final recorded plat told a different story. The boundary of Lot 18 extended farther east than it had on the preliminary drawing. The entire footprint of the guest house fell inside that recorded line. The common parcel stopped outside it. There was no separate access strip, no guest house easement, and no notation giving the HOA a right to use the building. The documents were not equally important. One showed what the developer had considered during planning. The other showed the parcel configuration that had actually been recorded. That distinction also explained why the HOA's position had seemed plausible at first. The building had once been intended to serve the community. The path, the old marketing language, and the preliminary label all came from that earlier plan. Intention, however, was not the same as a recorded property right. I sent the final plat to Evan, the manager, and HOA counsel. I placed it beside the tax map and highlighted the same boundary on both. Then I proposed the least disruptive solution available. Suspend the listing, stop taking reservations, keep everyone out until the surveyor completed his fieldwork. If the final record somehow supported the HOA, we could address that after a proper review. I was not asking Evan to admit wrongdoing. I was asking him to stop relying on a disputed plan while the controlling documents were being checked. His response did not challenge the plat directly. Instead, he said the developer was reviewing the broader implications of changing the guest house's status and needed more time before altering community materials. That phrase stayed with me. If this were only a disagreement over one old map, the safest response would have been a pause. Evan seemed more concerned about what removing the guest house would affect elsewhere. The preliminary plan finally explained how the mistake had started. It still did not explain why the developer was working so hard to keep it alive. The phrase, broader implications, changed the question I was asking. Until then, I had focused almost entirely on ownership. I wanted to know why the HOA believed the guest house belonged to the community, and which document it thought gave residents a right to use it. Evan's response suggested that the building mattered somewhere beyond the property file, so I stopped asking only, how do I prove this is mine? I started asking, who is relying on the claim that it belongs to the HOA? The resident portal gave me the first answer. The guest house had its own booking page, calendar, photographs, and description. Residents were told it could be reserved for visiting family. The page stated that a deposit was required before a weekend could be confirmed. The developer's public website gave me the second answer. The same building appeared in a gallery of community amenities, described as a shared guest suite available to homeowners. A downloadable sales brochure included it beside the pool, green space, and walking trail. The third answer came from documents I already had a right to receive. The annual budget package emailed to every HOA member included a line for cleaning and maintaining the guest suite. The amount was modest, but it showed that the building had been folded into association operations as though its status had already been settled. A current amenity sheet was available as a public download from the developer's sales page. It listed the guest house as part of the package offered to buyers in the final phase. By then, I had 4 separate uses of the same claim: the HOA property list, the resident booking system, the association budget, and the developer's sales materials. Removing the guest house would not merely correct a website. The developer might have to revise brochures, update buyer disclosures, cancel bookings, and explain why an advertised amenity was privately owned. That was the midpoint of the dispute. I stopped sending the same ownership argument back to the board and contacted a title attorney. I organized the records into 5 groups: what I owned, where the boundary appeared to run, what the HOA claimed, how the guest house was being used, and what continued after I objected. The tax map had exposed the contradiction. The final plat showed which plan had been recorded. Now I needed someone to determine whether the HOA had any legal right that survived those documents, and what would happen if current transactions had been built on a right that did not exist. The title attorney began by separating title, boundary, access rights, and transaction use. After reviewing my packet, she prepared a formal notice to the HOA, the management company, and the developer. It did not accuse anyone of fraud or demand a public confession. It asked for immediate steps that would prevent the dispute from getting worse while the remaining records were reviewed. The HOA was told to suspend access, remove the booking link, preserve every related record, and identify each document it believed created an ownership or access right. The developer was asked to identify where the guest house appeared in buyer materials and whether pending purchasers had received those materials. The management company was instructed not to send another contractor onto Lot 18 and not to issue a door code, reservation confirmation, or maintenance order for the building. The notice included the deed, final plat, county map, preliminary plan, portal screenshots, contractor work order, and proof that the survey was underway. It also gave Evan a clear exit. He could temporarily remove the guest house from the amenity system, tell residents its status was under review, and correct the records after the survey and title analysis were complete. He did not have to concede liability. He only had to stop treating a disputed private building as though the HOA's right to use it had already been established. For a few hours, I thought the notice might work. The manager changed the wording on the portal. The announcement that the guest house would open that weekend disappeared. The building itself remained on the amenity list. The booking calendar was still visible. Its status now read, "Access temporarily delayed." That wording preserved the idea that the guest house belonged to the association and suggested that I was merely blocking access. Evan's response arrived later that day. He said the developer needed time to evaluate the effect of any change on community operations and pending sales materials. By then, he had the final plat, tax map, deed, and noticed that a license survey was in progress. He also had the simplest option: pause everything until the ownership question was resolved. Instead, he changed the description without changing the claim. That was when an old planning mistake became a documented decision to keep relying on it. The surveyor needed almost 2 weeks to complete the records review and fieldwork. During that time, the booking page stayed online. A second reservation request appeared after the formal notice had been delivered, and I saved the page with the date and time visible. The management company also sent residents an update, describing the dispute as a temporary access obstruction. It did not say the HOA was reviewing whether it owned the building. It suggested that the guest house remained a community facility and that the only unresolved issue was getting inside it. The developer's brochure still showed the cottage among the neighborhood amenities. A follow-up email from a sales representative to a prospective buyer also mentioned overnight accommodations for residents' guests. I did not contact the buyer or pretend to be interested in a home. Several days later, the buyer's attorney shared a redacted copy of that email with my title attorney after the same amenity issue appeared in the buyer's closing review. I received it through my lawyer, with names and financial details removed. The formal notice also required preservation of booking records. When HOA counsel produced a limited booking ledger, it showed that 3 deposits had actually been processed before access was suspended. That clarified the money state. There had been more than requests. The association had received funds based on the disputed listing. Then the surveyor completed his work. He located the recorded monuments, compared them with the final plat, and measured the position of the guest house. His survey placed the entire structure approximately 11 feet inside Lot 18. The old walkway from the common green ended at the boundary. Nothing in the field supported a separate access corridor continuing to the building. He was careful about what that meant. His work located the boundary. It did not prove why Evan had continued using the old plan, and it did not decide whether anyone had committed fraud. But the survey removed the HOA's easiest defense. The county map could be dismissed as approximate. The final plat could be described as difficult to interpret. A licensed field survey tied both records to the physical ground. The guest house was not sitting on the line. It was not partly within the common parcel. It stood well inside my property. By then, the evidence showed a clean sequence. The HOA listed the building. I objected. The developer received the county map, deed, and final plat. My attorney demanded a pause. The association continued presenting the building as common property, and the booking ledger showed money collected after the system had been activated. The dispute had moved from a questionable label to documented reliance. The survey gave the title attorney something the earlier records could not: a physical boundary tied to the recorded plat. She compared it with my deed, title policy, subdivision declaration, recorded easements, and the developer's conveyance records. Her written analysis was careful. The deed conveyed Lot 18 to me. The final plat placed the guest house inside that lot. The survey confirmed the building's position on the ground. None of the recorded easements gave the HOA or its residents a right to cross the property for guest house access. The association declaration allowed the HOA to manage common facilities, but that authority applied only to property or rights the association actually held. It did not let the board designate a privately owned structure as common property simply because an earlier development plan had described it that way. She did not call the preliminary plan fraudulent. She called it superseded. That distinction preserved what the evidence actually showed. The earlier drawing explained why the sales cottage had once been expected to become a community amenity. It did not create a present ownership interest after the final plat placed the building inside Lot 18. My attorney sent her title position to HOA counsel and the developer. She demanded written confirmation that the association would remove the guest house from its records, stop booking activity, and abandon any claimed right of access. At almost the same time, the issue reached the 2 pending sales. The same closing attorney represented both buyers in separate transactions. After reviewing the amenity materials, she asked the developer to produce the recorded instrument showing that the HOA owned the building or had a legal right to use it. The developer sent the preliminary site plan. The closing attorney asked for the final recorded instrument. There was no deed transferring the guest house to the HOA. There was no recorded easement for resident access. There was no license signed by me or a previous owner of Lot 18. The closing attorney did not decide title for the entire community. She advised her 2 clients that the sales disclosures described an amenity the developer could not document. Acting on that advice, both buyers instructed the escrow company not to release their funds until corrected disclosures were delivered and reviewed. That was the gate. The developer could still argue with me about how the old plan had been interpreted. It could not force those buyers to close on the existing papers. The dispute was no longer contained inside the HOA portal or a private exchange between lawyers. Professionals responsible to the buyers were now asking whether the sales representation could be supported. They did not declare the HOA guilty of anything. They did something more practical. They paused the transactions. The closings did not collapse. They paused because the buyers withheld authorization to release their funds. That distinction mattered. I had not frozen anyone's sale, and no government office had issued an order. The buyers had received information that did not match the property records, and their own attorney advised them to wait for a cure. Within a day, the developer removed the cottage photograph from its public website. The downloadable amenity sheet disappeared soon after. The HOA manager disabled the booking calendar and sent residents a notice saying the guest suite was unavailable while property records were being reviewed. For the first time, the message acknowledged an ownership question instead of blaming an access delay. The 3 reservations tied to processed deposits were canceled, and the ledger was updated to show refunds pending. No new money was accepted. Those changes were important, but they did not resolve the underlying claim. The guest house still appeared in an internal HOA property inventory, and Evan had not agreed that the association lacked a right to use it. About a week after the buyers paused their transactions, the HOA held a special board meeting. I attended with my title attorney. Evan appeared with HOA counsel and the property manager. The purpose was not to decide criminal conduct or stage a public trial. It was to determine what the association could continue claiming while the developer tried to cure the sales documents. The preliminary plan was displayed first. Then the final recorded plat was placed beside it. The difference was difficult to ignore. The older drawing showed the cottage connected to future community land. The recorded plat placed the structure inside Lot 18. The survey confirmed that location on the ground. The title review found no deed, easement, or license giving the HOA access. The booking ledger added another problem. The association had accepted deposits based on the common property designation. The developer had used the same designation in materials provided to buyers. Several resident elected board members asked why the guest house had remained online after the final plat was delivered. They also wanted to know who would pay the refunds, legal expenses, and correction costs. Evan did not confess to intentionally taking my property. He did not need to. The record showed that the listing supported more than a mistaken label. It supported a booking system, an operating budget, and a sales promise. Removing it earlier would have forced the developer to correct all 3. That was why the claim had survived the first objection. Now the same dependency was working in reverse. The developer could not move the 2 closings forward until the buyer disclosures were corrected, and the HOA could not restore the booking page without producing a property right no one had found. Negotiations began the following week and lasted a little more than 3 weeks. My attorney made the goal clear. If the HOA and developer corrected the records, stopped using the building, and covered the direct costs their mistake had created, there was still a path to resolve the matter without seeking an injunction. The first issue was authority. The developer could not sign away a claim belonging to the HOA, and the HOA could not release a claim belonging to the developer. Each entity had to act for itself. The HOA board therefore adopted a written resolution authorizing its president and secretary to execute a recorded declaration and release. That instrument confirmed that the association claimed no ownership, access, booking, or management right in the guest house or the portion of Lot 18 surrounding it. The developer executed a separate recorded release disclaiming any remaining development, marketing, or access claim based on the preliminary plan. Both documents referenced the final plat and license survey. Copies were placed in the association's permanent property file, along with the board resolution. A future manager would not be able to open the old site plan without also seeing the documents that superseded it. The second issue was the sales material. The developer agreed to send corrected amenity disclosures to the 2 pending buyers and remove the guest house from every brochure, map, website, and sales packet still in use. The transactions could continue only after the buyers reviewed the correction and authorized their escrow company to proceed. The third issue involved money. The 3 deposits shown in the booking ledger had to be refunded. The developer also agreed to reimburse my documented survey cost and title review expenses. Those payments were settlement obligations, not damages awarded by a court. I insisted on one additional protection. The correction costs could not be shifted to homeowners through a special assessment. Residents had relied on the information they were given. They had not created the old plan, approved the listing, or continued using it after the objection. The physical cure was straightforward. The management company canceled the keypad work order. The reserved keypad kit and common property sign were returned to the vendor. The old walkway from the green space would be ended at the recorded boundary with landscaping and a visible marker, while my private path from the house to the cottage would remain untouched. The HOA also changed its internal process. No building, parcel, or access right could be added to the common property inventory without a title check based on recorded documents. Preliminary plans could be stored for historical reference, but they could not be used as proof of current ownership. Evan did not lose his company or face criminal charges. That was never the issue. What he lost was the exact advantage he had tried to preserve. The guest house could no longer support the booking program. It could no longer appear in the developer's sales package. And the old plan could no longer give the HOA control over a building it had never received. Once both releases were signed and submitted for recording, the dispute stopped being a question of which map the association preferred. The answer was becoming part of the property record. The recorded documents changed the paper trail first. Certified copies arrived from the recorder, showing that the HOA and developer had separately disclaimed the rights they had been asserting. The board resolution, final plat, and survey were cross-referenced in the association file. The resident portal changed next. The guest house listing disappeared from the amenity page. The calendar was removed, the photographs came down, and the community map was replaced with one that matched the final parcel configuration. The booking ledger later showed all 3 deposits refunded. A notice to residents stated that the guest house was private property and was not available for HOA use. It did not accuse residents or ask them to absorb the cost. A separate correction went to the 2 pending buyers. The revised materials removed the cottage from the amenity list and explained that the building was part of Lot 18. After reviewing the change with their attorney, both buyers authorized their escrow company to proceed. No one lost a home because I defended mine. At the property, the physical changes were quieter than the paperwork. The keypad equipment never reached the door. The common property sign was never installed. A landscaping crew shortened the old path from the green space and placed a boundary marker where the common parcel ended. They did not build a wall or block the green. They simply stopped the HOA path before it reached my land. The private walkway from my house to the guest cottage remained where it had always been. The reimbursement arrived after the settlement documents were completed. It covered the survey and title review I had paid for. It was not a court award or a dramatic penalty. It was the direct cost of correcting a problem that should have been paused when I first objected. The HOA updated its internal inventory as well. The guest house was removed from the list of common facilities. The preliminary site plan stayed in the file for historical reference, but it was marked superseded. Beside it were the final plat, license survey, board resolution, and recorded releases. That mattered more to me than an apology. A verbal promise could be forgotten when the board changed. A corrected property file gave the next manager and the next board the same answer before either tried to reopen the dispute. The tax map had been the first record to expose that the HOA's story did not match the county parcel data. It had not settled ownership by itself. The deed showed what I bought. The final plat showed the recorded configuration. The survey tied that boundary to the ground. The title review found no recorded HOA right, and the buyer's decision to pause their closings forced the developer to correct the promise it had been trying to preserve. A week after the releases were recorded, I opened the resident portal one more time. There was no booking icon, no shared suite description, and no notice telling residents how to enter. Behind my house, the guest cottage stood where it had always stood, inside Lot 18, connected to my utilities, reached by my walkway, and finally absent from every HOA system that had tried to turn it into something else. The first person to stay in the guest house after the dispute was my brother. There was no ceremony. I unlocked the door, carried in fresh sheets, and showed him where the coffee was. That ordinary moment was the restoration I had wanted from the beginning. The building was not a prize or leverage against the HOA. It was part of my home, and I could use it without wondering whether someone had been promised a reservation or sent a code to my door. So would the tax map have been enough? For me, it was enough to reveal the error and start the right questions. It was not enough to finish the dispute. The deed, final plat, survey, title review, and corrected transaction records completed the proof. Outside, the old path ended at the boundary. Online, the booking page was gone. And behind my house, the guest cottage was once again exactly what the recorded property file said it was. Private property inside lot 18.